parole and inspected to the United States. Can I adjust status based on employment-based adjustment of status? In this video, we are going to answer this question once and for all. We hope so. Let me answer this question. It was asked to me by a client because this client of mine got parole to the United States, and they are a DACA recipient. They want to know if they can adjust status based on I-140 being approved. How can you adjust status? What are the bases for adjustment of status? Remember, adjustment of status is the process by which you apply for a green card without leaving the United States. So pretty much you apply for the green card inside of the United States. What are the bases? Okay. Number one, must be inspected and admitted, or inspected or paroled. This is the first requirement. And this requirement was already met by the client because she was inspected, she was paroled to the United States. That is met, okay? Be eligible to receive an immigrant visa. Be eligible simply means that you have I-140 approved. This is the context of employment base, right? I-140 is approved. Then the person is eligible because they have I-140 approved. If it was marriage based, then we're gonna say I-130 is approved. If it was humanitarian, we're gonna say asylum is approved, or T visa is approved, or U visa is approved. But this is employment based, okay? The second requirement has been met as well. Be admissible to the United States. Be admissible to the United States. That's where a lot of people have problems. And I'm going to elaborate more on admissibility or inadmissibility issues. Be inadmissible. In the context of my client, she's not admissible because of failure to maintain legal status. Remember, DACA is not a status. Although unlawful presence stopped to be accumulated, but still it's not a legal status, right? So therefore, this person is not admissible to the United States because of failure to continuously maintain lawful status. Another person will be, an example will be, let's say the person has I-140 approved and then they have asylum pending. That person as well will be inadmissible to the United States because of failure to maintain legal status. Asylum pending, it's not a status. It's pretty much just authorization to stay while the case is pending. And it doesn't stop unlawful presence to be accumulated. So that person too will not be admissible to the United States. And lastly, have an immigrant visa immediately available at the time you file for adjustment. That's where we go to the visa bulletin to find out whether the visa is immediately available. We'll look at filing dates. It's going to tell you under employment base, it's going to tell you the date of filing. If the dates are available, then you meet the requirement. If it's not available yet to be filed, then you don't meet the requirement as well. You can wait. But in the particular case of my client, she's not admissible. Therefore, she has to go through consular processing. And for her, it's going to be better because she's a DACA recipient. She doesn't accrue unlawful presence. Therefore, the 10 and 3 years bars do not apply to her. Or she's going to have an emergency parole to go for the interview when the time comes. Okay? So, and this analysis really apply to pretty much everybody when it comes to employment base, unless you have an exception. And what is the exception? The first exception is 245I. 245I simply means that if you have some type of old petition, it can be employment based, family based, labor certification. If you have that old petition that was approved or approvable at the time it was filed, cutoff date is April 30th, 2001, then you can use it in connection to your I-140 in order to waive inadmissibility issues as far as entry without inspection, work without authorization, and unlawful presence. That's the first exception. If you meet that, then you can adjust under employment. The second exception will be if your last entry was an admission, and after your last entry, you did not accrue in aggregate 180 days of unlawful presence and work without authorization. An example would be, let's say you've been here in the United States for too long, and then at some point you went out, then you came back with H-1B visa or visitor visa, and then at the time you're filing your adjustment of status, you haven't accrued unlawful presence for more than 180 days, 6 months, then yes, you can adjust status under employment. We go with the last entry. It has to be an admission, not a parole, when it comes to adjustment under employment. That's how it's gonna play out. Okay. And then another exception will be technical reason. Technical reasons, it's really strictly defined, and I've talked about it before. You can refer back to my previous video, but in short, I will say that you can claim that you failed to continuously maintain legal status because of technical reasons. For example, USCIS failed to adjudicate your other petition within reasonable time, stuff like that. So, but that one really has to be an argument that can be accepted or declined. But this is how you adjust status under employment. If you don't fit under those exceptions, it's just advisable for you to go through consular processing, provided that you take those precautions, right? Like waivers, parole, so that you can come back, right? That's it. If you need a consultation with me, you can schedule it by using the consultation link in the description box below. Until next time, bye-bye.